Hello and welcome to the Landlord Law Firm's Landlord Advocate video newsletter. I'm Robert Chesson. In this month's Core Topic video, we're going to discuss a question that we've been getting on a regular basis from various clients around the state. And that is, what is it that you want to see to help us present a case to the courts? This question has come in numerous times over the last several months from clients who are investigating the possibility of bringing a lease violation nuisance case to the courthouse. And while we'd like to say we want to see everything, we recognize that that isn't always possible, nor do you always have those things that we might otherwise hope to have when you bring a case to us. So let's talk about the stuff that you have that you can deliver to your landlord attorney that will help them evaluate what your legal rights might be in a particular case. Usually, the most important thing that you can have is your own specific observations, things that you actually saw happen. Ideally, you should write those down at or about the time they actually happened so that you can capture for your memory what it was that you actually saw. Other eyewitness statements from your maintenance staff or even other residents in the community would be equally as helpful to determine exactly what happened and what your rights might be. Reports from the authorities are another great category of information that would be very helpful, whether it be police reports, fire reports, health inspection reports. Those various reports from the authorities who are responsible for the conditions on the premises would be very valuable depending on the circumstances of the case. If you have recordings, whether they be security cameras, whether they be somebody's iPhone recording of a particular event, those can often also be very useful in evaluating the particular case that you'd like to bring. And then ultimately, written documentation that actually pertains to the circumstances of your case. For example, if you're bringing a recertification case because somebody's failed to recertify their eligibility for the program that you manage on the premises, all the various documentation, including the notices that you provided, the responses that you may have received, or the fact that there are no responses, is very valuable information for your attorney to consider. Ultimately, the best thing you can do is be over-inclusive if there's a question on something that you have about whether or not it could be valuable. Your attorney will have a chance to look at it, have a chance to consider it amongst all the other information that you've provided, and give you the best advice they can on whether or not it will assist with the case as they go forward. And lastly, it is always very important to keep a running dialogue going with your attorney about the information they've got, the information they need, so they can actually help you make the best decision for your property. Thank you for joining us this month for our edition of the Landlord Advocates video newsletter. We look forward to seeing you next month. I'm Robert Chesson.